Good morning again, and welcome to our second week of Introduction to European Law. How did we go last week? Do any of you have questions? Any questions from any of you? If not, then it means we are getting somewhere. Today, we are going to talk about the principles of European law too. Remember, I talked about direct effects, indirect effects in our first lecture. Today, I will try to talk more about what direct effect is all about or what indirect effect is all about, especially when it comes to regulations and directives. Do we have questions? No questions? Now, let's talk about direct effect. What is direct effect? We talked about it briefly before, and I don't know if any of you can tell me what direct effect means. If not, let me go ahead and tell you all about direct effect of directives or regulations under EU law. EU law is binding and enforceable for all. 2. All of its acts may be directly applicable, that is, immediately applicable in the territory of member states against their state bodies. Individuals may claim provisions of EU to be applied at the national level. So when somebody asks you what is direct effect, you simply tell the person it means that EU law is binding and enforceable for everybody, and all its acts may be directly applicable, immediately applicable in the territory of member states against their state bodies, and individuals may claim provisions of EU law to be applied at the national authority. This is what direct effect means. Now, having understood that, there are different types of direct effects. 1. The Treaty of the European Union has direct effect. The regulations of the European Union has direct effect. And the directives of the European Union has direct effect. Types of direct effects could be either vertical or horizontal. Vertical direct effect is where the European law creates individual rights against the state. In other words, when there is a law or a right created by the European law for individuals against the state, it means that law is vertical. So, a state dealing with their subordinates in a vertical effect right. While a horizontal direct effect is where the European law creates individual rights against other individuals. In other words, equal treatment, equal rights between individuals. If an individual does anything wrong to a fellow individual, that individual could claim horizontal direct effect to challenge whatever wrong he or she incurred from a fellow individual. This is what they mean by horizontal direct effect. Let me repeat it again. There are three types of direct effects under European law. The European Treaty has direct effect. The regulations of the European Union has direct effect, and directives of the European Union have direct effect. These types of direct effects could be either vertical or horizontal. It is vertical when it concerns individual against the state, while it is horizontal when it involves individual against a fellow individual. Now, we could test these direct effects of a treaty or of a regulation or of a directives in the following way. The rule must contain personal rights. Secondly, the direct effect may be recognized if the rule above is clear, precise, unconditional, not leaving any place for assumption. In other words, it has to be very clear and unambiguous. If such rule is ambiguous, then you could challenge it. But the law, the European Constitution, or the treaty forming European Union, or the treaty creating this directive or regulation made it clear that for a directive to have direct effects, it must be clear, it must be precise, it must be unconditional, not leaving any place for assumption. Are we making sense? Now, let's talk about direct effects or vertical direct effects, which we say is between the state and the individual, while horizontal direct effect is between individual and individual. Are we making sense? Now, how does a treaty have direct effect? A treaty, we know, is like the Constitution, but now we learn from the law now that it has direct effect. How? This means that a citizen might be able to use a treaty in a domestic court. If you feel the state encroaches on your rights and you can find the encroachment in any section of the treaty, then that gives you a direct effect to challenge the abuse or the breach. So, a treaty has direct effect when the citizen might be able to use a treaty in a domestic law or in a domestic court or in a national court. According to Spirit, the general scheme and the wordings of EEC Treaty, in particular Article 12, must be interpreted as producing direct effect and creating individual rights which national court must protect. Did you hear that? As far as the treaty is talking about the betterment of the union, each individual has the right to challenge this treaty when they feel the treaty somehow encroaches on their rights. And the national court must protect that right of the individual. The provision of the treaty laying down prohibition on custom duties, for example, and charges having equivalent effect, impose precise and clearly defined obligations on member states which do not require any subsequent intervention by community or national authority for their implementation. For this reason, these provisions directly confers rights on individuals concerned. This was a judgment reached by a court in the Netherlands in a case 2662 Van Gent and Loos. This case, you will come across it often when you are studying international law or European law or business law. This case is a landmass case that is cited everywhere. And that is where the judge I mentioned stated categorically that the general scheme and the wordings of the EEC Treaty, Article 12, must be interpreted as producing direct effects and creating individual rights which national court must protect. The provisions of this treaty laying down prohibitions on custom duties and charges having equivalent effect imposes precise and clearly defined obligations on member states which do not require any subsequent intervention by community or national authority for their implementation. For this reason, these provisions directly confers on individuals concerned. Judgment 2662 Van Gent and Loos. We will eventually talk the details of this case as we proceed, but I am referring it now to give you a sort of foundation on how direct effect of treaty involves individuals. Are we okay? Now, treaties can have both vertical and horizontal effects, where they are clear, precise, and unconditional, as in the above cited case. But when it is not clear, it is not precise, and it is not unconditional, the individual challenging the treaty might end up somehow in losing his or her claims. So, treaty can have both vertical and horizontal effects where they are clear, precise, and unconditional. In other words, not all treaty can individual claim their rights. It has to be very clear that it gave or it confers right to that individual for him to have locus standi to challenge whatever breach that was done. Are we okay? Now, let's talk about the direct effects of regulations. Regulations are directly applicable and have both vertical and horizontal effects. The citizens can use them in a domestic court. By reasons of their nature and their function in the system of the sources of community law, all regulations have direct effect and are, as such, capable of creating individual rights which national court must protect. Did you see how law works? This is not the kind of law that is made or created in Africa where they write something and in the law courts they talk bullshit and mess up the system. This is a functioning system, and we are talking about the functionality of direct effect of regulations under EU law. Now, let me repeat it again. Regulations are directly applicable and have both vertical and horizontal effects. The citizens can use them in a domestic court. By reasons of their nature and their function in the system of the sources of community law, all regulations have direct effects and are as such capable of creating individual rights which national courts must protect. Case number 4371, Polity. Now, how do they implement a directives? Implementing a directive follows the following stages. A member state which fails to introduce a directive is breaking its obligation under the treaty and breaching European law. Article 5 of the Treaty European Law obliged every member state to make sure that a member state does not violate directives, must follow the directives, must implement the directives, must harmonize a directive within a given period. The European Commission will usually bring a case against a state in the Court of Justice to force it to implement the directives. The Court of Justice can impose penalties such as fines against member states that breaks this obligation under the treaty. If a member state fails to implement a directive, it may be possible for a citizen to still use the directive and challenge the state in court. Direct effects of directives. Direct effects of directives could be vertical effect, just between states and the individuals. There is no horizontal direct effect of directive. In other words, an individual can only challenge a state when a state violates a directive. But an individual cannot hold a fellow individual responsible under horizontal direct effects of directives. This, we will talk about it later when we talk of what they call Frankovich principle. Frankovich principle is a situation which the European Court of Justice introduced when they find out that a lot of states are violating these directives and individuals become victims to this. When another, for example, if I have a company and my company, for one reason or the other, did not follow the directives and I injure another company, so that company will not hold me responsible because I will claim that, okay, the state did not do this, the state did not do the directive properly, therefore you cannot hold me responsible, blah, blah, blah. So in that case, the European Court of Justice in Frankovich case introduced a principle that we are going to deal with as we go along in this course. Now, vertical direct effects of directives. If a state fails to introduce a directive, the citizen can still use the directive in court, just like I said. The directive is sufficiently clear. For example, in Van Duyn versus Home Office. Van Duyn is a Netherlands company and Home Office was in the UK. And there was an issue which we are going to deal with as we go along in this course. The claim is against the state or a state organization. See also Foster versus British Gas. We will deal with these cases eventually as we go along, but my point here is that if a state fails to introduce a directive, the citizen can still use the directive in court to challenge the state and not the company or individual that might have somehow violated the citizen's rights. These two cases I referred to, we will deal with it eventually as this lecture progresses. Therefore, there is no horizontal direct effect of directives, especially if a state fails to introduce a directive. The citizen cannot use the directive in the court unless the claim is against the state or a state organization. So you cannot challenge the breach of a directive that was breached by an individual. You cannot challenge this, you cannot sue that individual. You have to sue the state direct. But that directives must have conferred rights to you as an individual somehow. We will deal with this as we progress. It may still be possible to sue the relevant government for any loss caused by its failure to implement the directives under the Frankovich principle, which I said before that we will talk about. Okay? How are we doing, guys? You see, I can see that introduction to European law is becoming more legal than introduction to law, because now you hear me talk about articles or rights or power or courts. That is the form of European law, because we have to deal with a lot of challenges, legal challenges. We have to deal with a lot of abuse of treaty or challenge in court, and so it is a phone course. It is complicated though, but the earlier we start dealing with it gradually, the better it gets. Our duty here is to make sure you give your lecturer a nice A or B exam report. Now, let's talk about, we talked about direct effects. Then there is something they call indirect effect now. This indirect effect was not ab initio in the EU Constitution. However, the European Court of Justice introduced it because of a lot of confusion, lack of understanding of the law between states, a lot of mistakes about directives and so on and so forth. So this principle of indirect effect was introduced by the Court of Justice and it became part of the law. So what is indirect effect? So-called Euro-conform interpretation. It is based on loyalty principle. The court of a member state shall interpret the national law in such a way that it will be in conformity with the not implemented directives. Did you see this, what I explained? When European Union was being formed, you know, each country of Europe speaks their own languages. So what I understood as an English speaker about this law, a Dutch speaker might read it and translate it different way, and because of that there was a lot of confusion in implementing directives or implementing regulations. So the only way to solve this is for the court to intervene. And one of the things the court did was they said that each court of member states shall interpret the national law in such a way that it will be in conformity with the not implemented directives. In other words, for example, a directive was set by Netherlands and a directive was set by the European Commission, and the Netherlands tried to implement this directive, but because their language is Dutch, so they did not implement it properly as the European Commission has demanded or as Article 288 has demanded. So they breached the rights of the people. Now the people are challenging this breach in court. So what the European Court of Justice says that every court of every member state, no matter what the breach is, must interpret that breach to conform the agenda of the European Union. So the court is now becoming a sort of correctional institution where when legal interpretation is misplaced, so the court, it is now the obligation of the national court to make sure that they interpret or they reinterpret that mistake that was done so that the citizens will be happy and the state will be happy and the European Union will be happy. Win-win case. But the state may not decide against the law contra legem. This was established in a case Sabine von Coulson and Elizabeth Kaman. This case, we will deal with it later, but the purpose of citing this case is to tell you where the court established that no matter the breach that was committed by the state, it is now the duty of the national court to correct this mess. We will deal with these cases as we go on. Now, the most powerful intervention of the ECJ in this kind of breach of directives was what I said before, the Frankovic principle. This principle was established in the case between Frankovic and the Italian government. The principle allows citizens of member states to claim compensation from another member state for losses caused by the state's failure to implement a directive. Now, Frankovic, as you've seen, is not an Italian name. It is, I think, Polish or wherever. But he had problem with the Italian government because Italian government did not implement a directive that they were supposed to implement. And because of that, the company of Frankovic was affected and along the line, but it was an individual that breached or that Frankovic was trying to sue. So the result of the directives creates rights to individual. The content of those rights is able to identify in the provisions of the directives. There is a clear causal link between the state's breach of an obligation to implement and the damage suffered by individual. So it is not only that there was a breach. The person trying to sue or claim damages must establish that directives that was breached actually conferred rights to him or her. he or she also must also prove that whatever damage he or she is claiming has a causal link between the breach and the damage he or she suffered. So this principle was established in Frankovic versus Italy, which we are going to deal further as this course progresses. Now, the direct effect and indirect effect of a directive. A directive or the failure of the state to implement directives. One, it is the responsibility of the state for breach of EU law. So when a state fails to implement a directive, they have breached EU law. Okay? Possible responsibility of the state for damages against individual versus state. So, in other words, there is a vertical direct effect between individual and the state. Now, solution. When this is clear that the state violated EU directives and there is also the possibility of vertical direct effect, then the solution provided by the court is that direct effects only in individual versus state relationship can direct effect or vertical direct effect take place. But there is a breach of EU law and limited impact. Only rights of individuals against the state. Now, indirect effect. When there is no direct effect when it is a horizontal direct effect, that is, breach between individual and individual, the court of state will apply domestic law in accordance with EU law. There will not be a breach of EU law. No responsibility of the state. Did we understand what is explained here? What the court is trying to tell us is that in an indirect effect of directives, the court of state will apply domestic law in accordance with EU law. There will not be a breach of EU law. No responsibility of the state. So the European Court of Justice is now handing over every power to the national court. Okay, the state already messed up. You have to clean up the mess. You have to make sure that breach was amended. You have to, so that there will not be issue of that the state breached the EU law, because the national court is also for the states. You will not now say, okay, I will take the matter back to the state so that they will make it right. No. The ECJ demands the national court to make amend whatever mess that was created by the state. Thirdly, there is duty to recover damage. Breach of EU law exists and it only remedies for failure of the state. So, if the state or the national court fails to do what is needful, then the ECJ says, yeah, whoever is damaged has rights to be compensated. So if you guys are not ready to do what is needful, I am going to make sure the mess is properly corrected. So I'm giving you the opportunity to make sure you don't take the matter back to the state to correct. You either correct it yourself or I do it for you. So, duty to recover damages, breach of EU law exists and it only remedies for failure of the state. So, guys, I'm enjoying this European law already. How are you guys enjoying? Just take your time, listen to the tape once, twice, 3 times. Our duty here, I'm not your lecturer. Our duty here is to help you to make a better grade in your introduction to European law course, or introduction to law course, or introduction to international law courts. My name is Gabriel. I'm a lawyer, and I'm here to guide you to making better grades in your first year at the university or in your master's program. Thank you for listening and meet you again in our third lecture on the introduction to European law. Have a nice day and see you soon. Bye.